to read about security deposits first. On chapter 4, part 2. I haven't been there yet. In the first recording, we were talking about establishing a relationship with a tenant, how to advertise. Advertising a property that's already rented is something that I had read. There was some nice little tip in here about what language to use in your rental agreement. Nonetheless, let's move to chapter 4 about the security deposit. We'll speed through it. I'm curious if it has to be returned within a year or if it can be retained for the whole life. Maybe it depends on what the security deposit is for. What is a security deposit? Dollar limits on deposits. How much deposit should you charge? Last month's rent, interest, and account on deposits, separate accounts, interest, non-refundable deposits, holding deposits, how to increase deposits, handling deposits when you buy or sell rental property. Most landlords quite sensibly ask for a security deposit before entrusting hundreds of thousands of dollars worth of real estate to a tenant, but it's easy to get into legal trouble over deposits because they are strictly regulated by state law and sometimes also by city ordinance. The law of most states dictates how large a deposit you can require, how you can use it, when you must return it, and more. Many states require you to put deposits in a separate account and pay interest on them. You cannot escape these requirements by putting different terms in a lease or rental agreement. You may face substantial financial penalties for violating state laws on security deposits. This chapter explains how to set up a clear, fair system of setting, collecting, and holding deposits. It may exceed the minimum requirements affecting your property, but it will ultimately work to your advantage, resulting in easier turnovers, better tenant relations, and fewer legal hassles. If you have any questions of what's allowed in your state, you should get a current copy of your state's security deposit statute or an up-to-date summary of the Landlords Association. Citations for every state laws are listed in the state laws on security deposits table in the appendix. In addition, be sure to check local rights. Be sure to check local ordinances in all areas where you own property. Cities, particularly those with rent control, may add their own rules on security deposits, such as a limit on the amount you can charge or a requirement that you pay interest on deposits. This discussion is limited to security deposit statutes. Some statutes, states, Alabama, Idaho, and Louisiana, West Virginia, Wisconsin, and Wyoming do not have statutes on security deposits. That doesn't mean that there is no law on the subject. Court decisions, what lawyers call case law, is in your state may set the quite specific requirements for refundability of deposits, whether they should be held in interest-bearing accounts and the like. This book doesn't cover all this case law, but you need to check it out yourself to find out whether courts in your state have made decisions you need to be aware of. Contact your state or local property owners association or do some legal research on your own. See Chapter 17 for legal research advice. Related topics. Charging prospective tenants. I kind of want to see what Chapter 17 says. So related topics was charging prospective tenants credit check fees. Chapter 1, writing clear lease and rental agreement provisions on security deposits. Chapter 2, highlighting security deposit rules and procedures in move-in and move-out letters to the tenant. Chapter 7 and 15, and returning deposits and deducting for cleaning, damage, or unpaid rent. How to handle legal disputes involving deposits is in Chapter 15. So Chapter 17 is about legal research, so I'm just going to mark that chapter is one that we are going to probably navigate to if there's any extra time in this recording. Lawyers and legal research. I forgot there aren't any actual page numbers. They're just chapter numbers and sections of chapters. Okay. Finding a lawyer, compile a list of prospects. This is the type of content in this section. how not to find a lawyer, shop around, and this is legal research. Wow. Types of fee arrangements with lawyers, saving on legal fees. Costs can mount up, and it tells you what legal fees are. Include resolving problems with your lawyer, recommended reading on lawsuits. California landlords can handle eviction lawsuits themselves by using the Landlord's Law Book Evictions by attorney David Brown, Nolo Press. Contact your state or local department association for information on any step-by-step guides to evictions in your states. Represent yourself in court by Paul Bergman and Sarah Berman Barrett. Nolo Press offers more general advice on handling any civil lawsuits on your own or with a lawyer coach's help. Attorney fees in a lawsuit, do-it-yourself legal research, state, local, and federal law. Okay, so this will be where we want to go when we're done reading about security deposits. Do-it-yourself legal research, which then starts going into the state, local, federal law, state statutes, local ordinances. It's not very long. It's only like 3 pages. Federal statute and regulations, court decisions that explain statutes, court decisions that make a law. Check out law review articles, law reviews published by law schools and other legal periodicals. May also contain useful summaries of the law. The American Bar Association Journal, as well as a journal published by your state bar association, should be available in the law library. In these journals, you may find timely articles on legal issues that affect landlords. Be forewarned, though, that law school reviews contain articles by law professors and students and are usually of the more academic than practical interest. Local bar association journals and other publications aimed at practicing lawyers, on the other hand, are likely to be more practical. All right. I actually feel like reading this section more. Now, back to security deposits. What is a security deposit? All states allow you to collect a security deposit when a tenant moves in and hold it until the tenant leaves. The general purpose of the security deposit is to assure a tenant pays rent when due and keeps the rental unit in good condition. Rent you collect in advance for the first month is not typically considered part of the security deposit. State laws control the amount you can charge, see Section B, and how and when you must return security deposits. When a tenant moves out, you will have a set amount of time, usually from 14 to 30 days, depending on the state, to either return the tenant's entire deposit or to provide itemized statement of deductions and refund any deposit balance. See Chapter 15 for the rules on returning deposits. You can generally withhold all or part of the deposit to pay for unpaid rent, repairing damage to the premises, except for ordinary wear and tear caused by the tenant, a family member, or guest. Repairing damage to the premises, except for ordinary wear and tear. Cleaning necessary to restore this is the third part. Those are first 1 and 2. Cleaning necessary to restore the rental unit to its condition at the beginning of the tenancy outside of ordinary wear and tear. Restoring or replacing rental unit property taken by the tenant. That's 4. States typically allow you to use a deposit to cover the tenant's obligations under the lease or rental agreement, which may include payment of utility charges. To protect yourself and avoid misunderstanding with tenants, make sure your lease or rental agreement is clear on the use of security deposits and the tenant's obligations. See Clause 8 of the form agreements in Chapter 2. Many cities with rent control ordinances restrict deposit amounts. Before setting or raising a deposit in a rent-controlled city, be sure to obtain a copy of the rent control ordinance. A deposit by any other name is still a deposit. Any fee you charge up front is probably going to be considered legally a security deposit. In most states, it is illegal to collect non-refundable deposits. No matter what you call an upfront fee, it will usually be subject to all state laws that apply to security deposits. Dollar limits on deposits. Many states limit the amount you can collect as a deposit to an amount equal to 1 or 2 months of rent, and the limit within each state sometimes varies depending on the age of the tenant. Senior citizens may have a lower deposit ceiling, whether or not the rental unit is furnished, length of the rental agreement, and pets. For example, see state laws and security deposit limits below. In some states, the rent you collect in advance for the last month is not considered part of the security deposit limit, while in others it is. Section D covers last month's rent. Also see Section F, which covers non-refundable fees you may charge in addition to security deposits. So, exemptions for landlords. This is a table. These states exempt some landlords and rental properties from all or portions of state security deposit laws: Alaska, Arkansas, Georgia, Illinois, Maine, New Hampshire, New Jersey, New York, and Tennessee. Next page, state laws on security deposit limits. Here's the limit each state sets on the amount of security deposit you can charge. The term no statutory limit means that the state either does not have a statute covering security deposits, or has a statute, but it does not specify the amount you can charge. So for California, it's 2 months rent unfurnished, no waterbed, 2.5 months rent unfurnished, tenant has waterbed, and 3 months rent furnished, no waterbed, and 3.5 months rent furnished, tenant has a waterbed. Delaware, 1 month's rent on leases for 1 year or more, no limit for month-to-month rental agreements. District of Columbia, 1 month's rent. Florida, no statutory limit. New Jersey, 1.5 months rent. New York, no statutory limit. Pennsylvania, 2 months rent for first year of renting, 1 month's rent during the second and subsequent years of renting. All right. An inconsistent security deposit policy is an invitation to a lawsuit. Even if your motives are good, for example, you require a smaller deposit from a student tenant, you risk a charge of illegal discrimination by other tenants who did not get the same break. Chapter 5 explains fair housing laws and their impact on your business practices. It's hard to see how much deposit should you charge. Normally, the best advice is to charge as much as the market will bear within any legal limits. The more the tenant has at stake, the better the chance your property will be respected, and the larger the deposit, the more financial protection you'll have if the tenant leaves owing you rent. The market, however, often keeps the practical limit on deposits lower than the maximum allowed by law. Your common sense and your business sense need to work together in setting security deposits. Here are a number of considerations to keep in mind. Cover yourself with high-risk situations. I'm not going to read everything within here. Consider the psychological advantage of a higher rent rather than a high deposit. And there's an example. And single-family homes need a bigger deposit and gain a marketing advantage through a low deposit. Charge less than 1 month's rent to discourage tenants from considering the deposit as simply the last month's rent. And then last month's rent is discussed here, although I'll keep going. Many landlords have found that charging fees less than the last month's rent results in fewer tenants assuming incorrectly that deposit is simply an advance payment for the last month's rent. Section D below covers the topic of last month's rent. If you're worried about damage but don't think you can raise the deposit any higher, require renter's insurance. You can give the property an extra measure of protection by insisting that the tenant purchase renter's insurance, which may cover damage done by the tenant or guests. While you're at it, evaluate your own insurance policy to make sure it is adequate. Insurance is discussed at length in Chapter 10, Section K. If the tenant's security deposit is inadequate to cover any damage and there is no renter's insurance, or it won't cover the loss, you may be able to collect from your own carrier. D, less month's rent. It's a common but often unwise practice to collect a sum of money called last month's rent from a tenant who's moving in. Landlords tend to treat this money as just another security deposit and use it to cover not only last month's rent but also other expenses such as repairs or cleaning. Problems arise because some states restrict the use of money labeled as last month's rent to its stated purpose, the rent for the tenant's last month of occupancy. If you use any of it to repair the cabinet the former tenant broke, you're violating the law. Example, Some states, however, do allow landlords to treat last month's rent as just another part of the security deposit. You can apply it to the last month's rent or use it to cover damage to the premises. It's still a bad idea to call any part of the deposit last month's rent. Why? Because if your state restricts your use of the money, you've unnecessarily hobbled yourself. And if your state considers last month's rent part of the security deposit, you haven't gained anything. You may have even put yourself at a disadvantage because you're giving the tenant the impression that the last month's rent is taken care of. You would be better off if the tenant paid the last month's rent when it came due, leaving the entire security deposit available to cover repairs. Example, avoiding the term last month's rent also keeps things simpler if you raise the rent but not the deposit before the tenant's last month of occupancy. The problem arises when rent for the tenant's last month becomes due. Has the tenant already paid in full, or does he owe more because the monthly rent is now higher? Legally, there is no clear answer. In practice, it's a hassle you can easily avoid by not labeling any part of the security deposit last month's rent. Example, Artie has been renting. Clause 8 of the form agreements in Chapter 2 makes it clear that a tenant may not apply the security deposit to the last month's rent. Even with this type of clause, a tenant who's leaving may ask to use the security deposit for the last month's rent. Chapter 15, Section C discusses how to handle these type of requests. Deposit limits and last month's rent. Many states limit the amount you can collect as a deposit. See Section B above. If you collect money and label it last month's rent, it may count towards the total deposit limit if your security deposit plus last month's rent together exceed the deposit limit in your state. Check your state's rules. You can ask a state or local property owners association or do some legal research on your own. See Chapter 17 for legal research advice. Section E, interest and accounts on deposits. And most states, you don't have to pay tenants interest on deposits or put them in a separate bank account. In other words, you can simply put the money in your own pocket or bank account and use it as long as you have it available when the tenant moves out. Separate accounts. Several states require you to put security deposits in a separate account, sometimes called a trust account, rather than mixing the funds with your personal or business accounts. The idea is that by isolating these funds, it's more likely that you will have the money available whenever the tenant moves out and becomes entitled to it. In addition, separating these deposits makes it easier to trace them if a tenant claims that they were not handled properly. You are not required to set up a separate account for every tenant. If you keep one account, be sure to maintain careful records of each tenant's contribution. States that require a separate account for security deposits include Delaware, District of Columbia, Florida. Instead of keeping separate account, landlord can post a surety bond. Maryland, Massachusetts, New Hampshire, New Jersey, New York, Pennsylvania, Washington. California's not on here. Interest. Several states require landlords to pay tenants interest on security deposits. Of course, you may find that it helps your relationship with your tenants to pay interest on deposits, even if there is no law requiring it. It's up to you. Even among the states that require interest, there are many variations. A few states, such as Illinois, don't require small landlords less than 25 rental units to pay interest on deposits. Others, such as Iowa, allow the landlord to keep the interest earned during the first 5 years of tenancy. State laws typically establish detailed requirements, including 1 and 2, the interest rate to be paid. Usually it's a little lower than the bank actually pays, so the landlord's costs and trouble of setting up the account are covered. When interest payments must be made, for example, only at termination of tenancy or also annually. And notification landlords must give tenants as to the manner in which the security deposit is being held and the rate of interest. See Clause 8 of the form agreements in Chapter 2 for details on states that require this type of notification. Chicago, Los Angeles, and others cities, typically those with rent control, require landlords to pay or credit tenants with interest on security deposits, even if the state law does not impose this duty. A few cities require that the funds be kept in separate interest-bearing accounts. So even though they just mentioned LA, California is not one of the states that require interest on deposits. DC, Florida has an asterisk. Interest payments are not required, but when they are made, certain conditions apply. Illinois, Maryland, Massachusetts, Pennsylvania, New York, New Jersey, New Hampshire. I'm skipping a lot of states in case it's not obvious. Non-refundable deposits, Section F. Everyone understands what a deposit is. Money that you give someone expecting that it will be returned when you have done a particular act. For example, when you pay a deposit on soda bottles, you know that you will get your bottle deposit back when you return the bottles to the market. To call a deposit non-refundable is really a contradiction in terms. When you start with this realization, you have gone a long way towards understanding why there is such confusion regarding the proper use of non-refundable deposits. In general, state laws are often muddled in the subject of non-refundable deposits and fees. The statute of some states specifically allows landlords to collect a fee that is not refundable, such as for pets cleaning or redecorating, as long as this is clearly stated in the lease or rental agreement. See states with security deposit statutes that allow non-refundable fees below. Many states that have enacted security deposit statutes, however, specifically prohibit non-refundable fees, such as a fixed fee for cleaning drapes or carpets or for painting. All such fees are legally considered security deposits, no matter what they are labeled in the lease or rental agreement, and must be refundable. In states where there is no statute on the subject, the legality of non-refundable fees and deposits is determined in court. For example, the courts in Texas and Michigan have ruled that a landlord and tenant may agree that certain fees will be non-refundable. Holmes versus Canlin Management Corp. and Studelberg versus Practical Management Co. Generally, it's best to avoid the legal uncertainties and not try to collect any non-refundable fees from tenants. It's much simpler just to consider expenses these fees cover as part of your overhead and figure them into the rent. By avoiding non-refundable fees, you'll prevent a lot of time-consuming disputes with tenants. If you have a specific concern about a particular tenant, for example, you're afraid a tenant's pet will damage the carpets and furniture, just ask for a higher security deposit. That way, you're covered if the pet causes damage, and if it doesn't, the tenant won't have to shell out unnecessarily. Charging a set fee may actually backfire. If you collect $50 for cleaning, for example, but when the tenant moves out, the unit needs $100 worth of cleaning or stock. You've already charged for cleaning, and the tenant could make a good argument that you're not entitled to take anything more out of the security deposit for cleaning. Holding deposits. A holding deposit is usually offered by a tenant who wants you to hold a rental unit pending the result of a credit check or while coming up with enough money for the rent and security deposit, although some tenants may want to reserve a unit while continuing to look for a better one. Accepting a deposit to hold a rental unit open for someone is legal in some states, but almost always unwise. Holding deposits do you little or no good from a business point of view, and all too often result in misunderstandings or even legal fights. Examples. Another prime reason to avoid holding deposits is that state law, if any, on the subject is very unclear as to what portion of the holding deposit a landlord can keep if a would-be tenant decides not to rent or doesn't come up with the remaining rent and deposit money. In California, for example, the basic rule is that a landlord can keep an amount that bears a reasonable relation to the landlord's cost. For example, for more advertising and for more prorated rent during the time the property was held vacant, a landlord who keeps a larger amount is said to be imposing an unlawful penalty. If, contrary to our advice, you decide to take a holding deposit, it is essential that both you and your prospective tenant have a clear understanding. The only way to accomplish this is to write your agreement down, including the amount of the deposit, the dates you will hold the rental property vacant, the costs and terms of the rental agreement or lease, and conditions for returning the deposit or applying it to the security deposit. You'll need to check the state law carefully on this one. Now, it says states with security deposit statutes that allow non-refundable fees include Florida, New Jersey, and that's really all of the ones that I've been reading about. How to increase deposits. Especially if you rent to a tenant for many years, you may want to increase the amount of security deposit. With a month-to-month tenancy, you can increase a security deposit the same way you raise the rent, typically by giving the tenant a written notice 30 days in advance of the charge. Of course, you can increase the security deposit without increasing the rent as long as you don't exceed the maximum legal amount. If you have a fixed term lease, you may not raise the security deposit during the term of the lease unless the lease allows it. Local rent control ordinances typically restrict your right to raise deposits as well as to raise rents. And Section I, the last section in security deposits, is handling deposits when you Buy or sell property. When you sell rental property, what should you do with the deposits you've already collected? After all, when the tenant moves out, she'll be entitled to her deposit back. Who owes her the money? In most states, whoever happens to be the landlord at the time of a tenancy ends is legally responsible for complying with state laws requiring return of security deposits. That means that you may need to hand over the deposits to the new owner. Read your state statutes carefully as to how this transfer is handled, including any requirements that tenants be notified of the new owner's name, address, and phone number. If you buy rental property, make sure you know the total dollar amount of security deposits for a multi-unit building could be tens of thousands of dollars.